So, welcome. Today's presentation is on mortgage enforcement solutions, and let's just talk about the recent developments. My name is Geoff Rabideau. Some of you know me, and the other ones that have not had the privilege to meet me. It's nice to meet you. I take the privilege of meeting you. Thank you very much for attending. I am the principal lawyer here at Rabideau Law. And now, some of you may know us as Rabideau Law. Some may know us as Custom Closing. Now, Rabideau Law is actually the name of the law firm. And in the Waterloo region, where we've built up the practice, we've built up our goodwill, people know my name. But outside of the Waterloo region, my name was not very well known. So what we did is we called ourselves Custom Closing. And you'll see the branding in the bottom right-hand corner there, Custom Closing, powered by Rabideau Law. So that's just an explanation of who we are and what those two names mean. I've been a practicing lawyer for 12 years, I've been running my own firm for almost 12 years. In that time, I've completed over 10,000 real estate transactions, probably closer to 11,000 now. I checked my Google ratings this morning, and I've got a 4.8 rating out of 195 reviews. I'm still trying to get to that 200 mark. So hey, if anybody wants to give me a review, anybody enjoys this presentation, I'd love to hear a review from you. In terms of volume, I'm in the top 10% of all real estate lawyers in Canada. So that's volume-wise. We here at Rabideau Law have pioneered the custom closing remote signing process. So the remote signing process is where we used to send out a commissioner to our clients. The commissioner would show up at their home, meet the clients, and we'd sign on a tablet at that time with a lawyer such as myself attending via video conferencing software. Now with COVID, we've now pioneered the virtual signing process, which is where we're just using the video conferencing software and going directly to the clients. Now, a lot of other law firms are trying to keep up to us, but we've been doing this now for 4 years. We pioneered this process, so let them try and keep up, let's just say. Disclaimer, this, as a lawyer, I obviously have to think of CYA, so you cannot use anything I tell you today for legal advice. This is for educational purposes, but it is information that you can, it is useful information, but just let you know, you can't use this as legal advice, okay guys? So let's just give a primer on where we're at for right now. So we see that the COVID-19 pandemic has had a decided impact on the Canadian mortgage market. Unemployment has risen and has peaked at 13.7% as May this year. Now the numbers for June aren't yet because June obviously is not complete, but 13.7% unemployment in May. An estimated 600,000 Canadians have applied for mortgage deferrals through the major banks, and 16% of the bank books are subject to potential deferrals. Now these deferral plans are up to 6 months. Depending on whether or not the borrowers were in default prior to or not. Obviously, if you're in default prior to, you could not get a deferral plan. And a lot of people have just gone through deferrals, even when there were mortgages in good standing, a lot of them have gone through the deferral process. Maximum 6 months. So we should start seeing, we're about 3 months now, so you're gonna start seeing a lot of these deferral plans ceasing, and the clients will have to start making their monies again. So the borrowers will have to start making their payments again on those mortgages. What we've seen is a dramatic increase in the household debt. So the projections were saying that we might get a household debt as high as 130%, but the numbers have just come out and the household debt to GDP has just reached 176%. That equates to an estimate, projections of about maybe 20% of mortgage holdings are in risk of falling into arrears. That number is huge if you think about it, 20%. Now that's projections that have been provided. I obviously, at the end, I'm going to go through my numbers, and my projections aren't that high, but let's just say some pundits are saying 20% of mortgages are at risk of falling into arrears. So what are we offering today? Well, we're offering an insightful, concise educational overview of the process of mortgage enforcement, power of sale, and foreclosure. And we're providing essential information to help mortgage originators and real estate professionals guide clients. Really, I'm trying to educate you so you can guide your clients and avoid the whole process. That's my goal. If you want...
entonces, si tienes esa, o sea, exacto, si tienes esa capacidad de hacer eso, de repente podemos hacer esa vaina y yo...
Sorry, Juan. Now, if you want more information, my invitation is you can request a copy of this presentation, or if you want, I'll gladly present to you and your team. You have Bill Cook's information here. You'll see his phone number and email address. So just reach out to Bill, and we'll gladly present to you and your team. So let's start off with what happens. Where's the process start? And the process starts if in the event your client has missed a payment. So if a client has missed a payment, you have to understand there's two types of payments. One is the late payment, and one is a skip payment. So a late payment is a payment that is made, a late payment is a payment that is missed, but it is made up prior to the next scheduled payment. A skip payment is one that is not made up by the next subsequent payment, okay? So the difference, these have dramatic differences. So a late payment, typically a lender will give 15 days grace period in order to make that payment up. If the payment is not made by that 15 days, a late payment is typically charged, okay, a late fee. Typically, there will be no effect on the credit report if the payment is made prior to the next payment and the next payment is made on time. A skip payment, if you imagine, is the payment has been missed and it's not made until after the next subsequent payment. So if you imagine the payment, let's say is July 1st, this July 1st payment is missed and it's not made until after August 1st. Well, in this case, if you imagine, the August 1st payment is missed also. So it's a continuing missed payment schedule, what we call rolling payments. It's a rolling late payment as it continues. Now, rolling late payments are very important because a rolling late payment is where a payment is skipped and results in each successive payment being missed. The result is continued late fees and damage to the credit report. And the only way to stop these rolling late payments is to make up every payment that needs to be made and the next subsequent payment. That's the only way to stop it. Or to sell off the property and pay out the mortgage in full with those missed payments and late fees added on. Now, obviously, you guys are the professionals at this. You know all about credit report, but I'm just going to talk about this quickly, just give a brief on this. So mortgages typically report to the credit reporting agencies at the end of a month. If a late payment has not been made up by the end of the month, the borrower will receive a notation on their credit report, i.e. M2 or R2. The first missed payment is the most damaging to a credit score. It accounts anywhere from 80 to 100 points off the beacon score. So from your perspective, the most important thing is to not allow your clients or your borrowers, your clients, your customers, to encounter that first missed payment, because after that, it gets a lot harder for you to then get them a product or get them into a new, refinance them or get into another product, because now that score has taken a dramatic hit. Thereafter, each successive payment will affect their credit report, but it's less than 80 points off the beacon score. It's not as damaging as the first. However, I have to disclaim this. The effect on each borrower's beacon score is dependent on their current credit rating. So for example, if someone has a 520, well, it's going to be less damaging than someone that has an 820, okay? So let's just make sure that's known. The other side is the effect on the beacon score also depends on whether or not the creditor reports to Equifax or TransUnion. So for instance, credit unions typically don't report to Equifax or TransUnion, and also some street capital lenders don't. It is important to note that these notations, the missed credit scores and notations on the credit report, will stay on the credit report for 6 or 7 years. 6 years with Equifax, 7 years with TransUnion. So let's say that a payment's missed. The next thing is that it's a default. It's called a default. So if the default occurs, the lender will contact the borrower and give them an opportunity to cure the default. Other common instances of default are property taxes have not been paid, property insurance has not been paid, property is not kept in a reasonable state of repair, and the property is being used for any illegal or criminal purposes. Now, the last two typically don't come to the lender's attention unless, for instance, illegal or criminal purposes, well, let's say the cops get involved, or the property is not left in a reasonable state of repair or kept in a reasonable state of repair, that's typically where a work order, the city gets involved and issues a work order telling the homeowner to rectify something by either cleaning up their property or take care of it. Now, if there is a default and the borrower has not cured the default, then the lender can initiate power of sale proceedings. Now, the power of sale proceedings are initiated under the Mortgages Act. That's the law, the statute under which it gives the authority to the lenders to initiate these proceedings. In a power of sale, the lender takes possession of the property, but not title. They don't take ownership of the property. The whole point is that the lender takes the property, takes possession, and turns around and sells the property to pay out the money owing to them. After the property is sold, the former homeowner is entitled to any of the remaining equity after the sale proceeds and after everybody's been paid out. Most lenders would rather be paid out than go through these processes. Because if you imagine, the lender's not getting anything from this. The lender just wants their money back, right? They just want to be paid. So then they would rather have you refinance your client's properties and pay. Let's talk about the difference between a power of sale and a foreclosure. Power of sale, as you know, and foreclosure, they share many of the same legal documents and the same processes. You still have to go through the court for each of them. But in a power of sale, the lender takes possession of the property, not title. And any of the remaining money goes to the homeowner. In a foreclosure, the lender takes title, ownership of the property, not just possession. So in that instance, on a foreclosure, the lender can decide what they want to do with the property. They can keep the property, they could turn around and sell it, they could rent it out, anything such as that, okay? So that's the major difference. Power of sale is about money, foreclosures about ownership and title of the property. Now, when talking to people, a lot of people don't know the word power of sale. Because of American media is so prevalent, it always says foreclosure, foreclosure. So when people talk, they always think of foreclosures. But truthfully, power of sale is the more dominant one. And if in the event there are any excess proceeds, the courts would be reticent to allow a foreclosure to happen because the courts want to, obviously, the courts are based on equitable principles, and therefore the courts want the excess proceeds to go to the previous homeowners rather than a lender who's foreclosing on the property. So here we see a graph, a process of what's the steps in a power of sale process. So we see the first step is default and demand, which we've talked about. The next step, which we're going to talk about, is where they issue a notice of sale. If it's not cured at that point, then they're going to go to court and issue and serve a statement of claim. If they don't defend and win, then they're going to obtain a judgment and get a writ of possession, which means they can take possession of the property. And then they're going to file writs of seizure and sale, which means they can sell the property. After that, they're going to secure the property and manage the property, which costs money. They're going to oversee the sale of the property. They're going to get a realtor involved. They're going to convey the property, which is what real estate lawyers do. We convey properties. They're going to submit their main and supplementary claims to any of the mortgage insurers if available. They're going to assign the judgments if necessary. And then they're going to go after the sellers if there's a deficiency in the sale for any outstanding amounts still owing.
Hey, Geoff, I hope you don't mind if I interrupt real quick. Did you mention, or are you going to mention maybe later, why we might be in a power of sale situation versus a foreclosure situation?
I just mentioned it. No problem. I can talk to you about that.
Sorry, this is all new to me. Thank you.
Of course, no problem. So I'm going to go back. And so, yeah, if anybody has questions, don't be afraid to hop in. Like you can send me a chat, send me a question in chat, or just hop in on me, okay?
I think I get the difference. I just don't know, like, why would we end up in one and not the other?
Okay. So typically, here's what happens. Let's say you have a mortgage on the property for $183,000. Let's say the property is worth $200,000. Let's say there's a writ against the seller, or there's unpaid taxes for $40,000. In that instance, what happens is there's not enough, the sale price won't be enough to cover off the sale of the property. So typically what happens in that instance is you complete a foreclosure because you want to remove all the other entitlements to the property. Where with a power of sale, since there's equity still left in the property, the courts would require a power of sale to go that way. So that's typically the difference, right? If there's equity or no equity left in the property.
Oh, I see. Okay, so and it's up to the lender, basically. The lender would choose which way they're going to go.
Correct. And most times the lenders will take power of sale because it's a quicker process.
What if what if it is the case where they just owe a whole ton in property tax? Does the city then jump in and do a foreclosure?
Yeah, so the city would do what's called a tax sale. So actually, and for your guys' knowledge, you might want to, each city has their own tax sales. They typically happen once a year or a few times a year. And what you can do is you can actually get a pretty good deal on properties at that time. So what happens is, but here's the tricky part. In a tax sale, the city will say, hi, we're selling this home off for $36,000. And everybody's like, oh my God, look at this thing. Well, that's the amount of tax owing. So what they do is the city will sell it off for $36,000. Everybody's going to bid on it because they want this property. And then they find out after the fact, there's also a mortgage on the property that you have to take care of. Right? So that's why tax sales are different. You got to be very careful with the tax sale because the city doesn't care what's on it. They just want the tax money.
Okay, thank you.
But yeah, so in any instance, a foreclosure, power sale, tax sale, any of those things, it's always important to get, which is the next part, due diligence. Complete very thorough due diligence. The lenders do. So the first step is they want to do searches. So they want to complete a title search because they want to determine who's on title. They want to know if there's only one person on title, is this a matrimonial home? And therefore, is there a spousal entitlement and spousal interest where the spouse have to sign off? They want to know what's registered on title. Mortgages, liens, security interests, CPLs are certificates of pending litigation, which means someone's being sued because of that house, leasehold interests, anything such as that. And then next, they want to determine who resides in the property. So is it the registered owners or tenants? Because in each instance, it is treated differently. Michael's question is, the beacon score reduction of 80 to 100% due to a late mortgage payment. Where is this information from? Is this info for Equifax or TransUnion provided? So I actually have, I have a contact who works at TransUnion and Equifax, and I reached out directly to them to get that information. It's not posted anywhere. It was strictly by my own research, reaching out to them and having conversations with them. I attend a lot of speaking seminars, and I was at one all about credit, and there was an Equifax rep and a TransUnion rep, and I actually went and had a conversation with them about it. And that's why they put a disclaimer. It's based on the current beacon score at that time. So I apologize. It's not written anywhere. It's just where through my conversations with them. So continuing on here, we see that the due diligence is important. Now, once the lender has completed his due diligence, they're going to issue a notice of sale. So this is a document that starts the power of sale process. The issue of the notice of sale is issued by personal service, or it's registered mail to the last known address of the borrowers. I had a question. I did one of the seminars previously today, and one of the questions was, well, how do you know where they are? So from a lender's perspective, they can hire a lawyer to pull the last transfer when they bought the property. And on the transfer, when they buy the property, it will say the borrower's name, the borrower's date of birth, and the borrower's address. So if it's a rental property, they will typically have their home address. And if it's a property they reside in, they'll typically have that purchasing address, right? Sometimes it does say care of Rabideau Law, which would be the law firm. In that instance, it is a little bit trickier, but in that instance, we can reach out to, the lender can reach out to that law firm to try and see if they will accept service on behalf of those borrowers. Now, I'm going to talk about the process because here at Rabideau Law, I do have a mortgage enforcement department. So we do represent a lot of lenders, and we do a lot of mortgages. We do a lot of power sales here. Okay. So the knowledge I'm giving to you is also firsthand knowledge of everything we do. Okay. So the notice of sale has to be sent out to all the interested parties. So that would be any mortgage lenders, any other mortgage lenders, any secured parties. So for instance, a secured party might be like Snap Financial or Reliance. Any lien holders, construction liens, anything such as that, any tenants to the property, or any spouses if it's a matrimonial home. The notice of sale can only be delivered after the mortgage has been in default for 15 days. And the notice of sale will indicate that the property will be sold, but it cannot be sold for at least 35 days after. So this 35-day period is called a redemption period. And what it does is it gives the borrower an opportunity to cure the default. So it depends on the type of default. If the default is where the borrower has just missed a payment, but the mortgage has not yet matured, all the borrower has to do is pay off that single payment. And then that will cure the default and stop the entire process. However, if the mortgage has matured and there are still ongoing missed payments, in order to cure that default, the entire mortgage has to be paid out. So a refinance has to be completed. Okay? Where the borrower is unable to cure the default or to pay off the mortgage, the lender can issue a statement of claim. Now, my mortgage brokers and realtors, this is your window to get involved. Okay, so understand. So if the client receives a notice of sale, they have that amount of time there to refinance the property or to make this payment. So this is your window here to step up and save your client's home. Realtors, if in the event that the mortgage broker can't save the home, this is your opportunity to sell the property, get it listed, and try and get a firm offer on the property, okay? This is your window. Now, truthfully, and my brokers, my invitation to you, and here's I invite you to do this. I would be at this moment going through your book of business and seeing of your clients whose TDS and RDS were too tight, right? Whose numbers were so tight that if they started missing payments, they would lose the properties, okay? Also, look at who maybe is not an essential service and had tight TDS, right, and RDS. This is my invitation to you. This is an opportunity for you to start looking at those ones and maybe reach out to them. Be proactive. Ask them how they're doing and see if they're able to make the mortgage payments or if they have any concerns. Let them know you know the process. Let them know you're there to help them, right? Reassure them, okay? This is just my invitation to you. It's a good opportunity right now. And I think if you're proactive, you can actually help some of your clients save their homes and generate more business. Okay? Now, let's say you can't refinance the home and the home hasn't been sold. Then, after that 35-day window, the lender can initiate court proceedings. And they're going to do this by issuing and serving a statement of claim. So what happens is the lender's lawyer is going to draft up a statement of claim. They're going to take it to the court. They're going to file it with the court and get it issued. After that, they're going to serve it on the borrowers. Now, once again, serving on the borrowers would be the last known address and personal service, or serving on their lawyer, or you can personal serve at the address on an adult and then mail a copy the following days. All right. Now, and I see this a lot of people feel that if they're going to be served, they want to avoid it. Truthfully, that is the worst thing possible, because here's what happens. And we do this all the time. If we can't serve someone, we then go to court and say, Your Honor, we can't serve this guy. So what we do is we bring a motion to the court. We ask the court for help. And we say, Your Honor, we can't serve this guy. He's avoiding service. Will you accept service? And the court says, yes, we will accept service on his behalf. Now, the moment that happens, I can totally avoid going after the borrower, and I can just deal with the court. In that instance, if you imagine, the borrower has no idea what's going on. The borrower has sort of buried their head like an ostrich, and when they finally come out, their house is already gone. They have lost all control. So if you have a client that is avoiding service, tell them not to. Tell them get involved, take the documents, get a lawyer, slow the process down, give you the time to refinance the property, or give you the time to sell the property. But don't avoid the service. Don't avoid taking the documents. Worst thing possible. And also, if they take documents, tell them actually to do something with them. A lot of times I get people that say, oh yeah, I got the document, but did you read it? No, they don't read it. They just throw it somewhere and ignore it, okay? This is a very important process. If they want to keep their home, you got to get involved. So upon being served with the statement of claim, they have 20 days in order to defend, which means to submit a statement of defense. The goal behind this is to buy you more time, okay? So, and another way to buy more time is to submit a notice of intent to defend. So let me explain the process. Here's how you buy more time. Day one, you're served. day 10, actually, hold on, day 10, you submit a notice of intent to defend. So you have to submit a notice of intent to defend by day 10. If you do that, it then gives you an extra 20 days to submit your statement of defense. So in total, it gives you 30 days versus just the 20 days. So I serve you on July 1st, July 10th, your client submits a notice of intent to defend. That now gives you to July 30th to submit a statement of defense. July 30th, you submit a statement of defense, and now it takes it through the court process. The whole goal here is to slow the lenders down, right? Slow the process down, give you more time to refinance the property, give you more time to sell the property. That's the goal here, okay, guys? So what happens if you don't defend? If you don't submit a statement of defense, then the lender can bring a motion to the court, and they can submit, they want to, what's called note the borrower in default. So noting them in default means that the borrower can no longer defend, and it also means that the borrower is no longer involved. The borrower will no longer hear anything. It's completely out of their radar, and the lender can now deal directly with the court and move ahead. They can get a default judgment, they can get a writ of possession, and a writ of seizure and sale. What they do then is once they have that default judgment and the writ of seizure and sale and writ of possession, they register those with the sheriff's office. And the moment that is registered with the sheriff's office, another notation goes out to Equifax and TransUnion indicating that a default judgment has been registered against the credit report. Once again, another hit on the credit report. So once again, you guys don't want to allow your borrowers to get this far. You want to help them and stop this process. And all it does is the longer it takes in the process, the harder it's going to get for you to refinance them. So once the judgment is filed with the sheriff then has the instructions, the authorization to go take possession of that property. The sheriff will send out a notice saying, "Hi, homeowner, I'm coming to take possession of this property on July 1st. You have to be out by such and such date." If the sheriff shows up on July 1st and the homeowner refuses to vacate, the sheriff will come back with the police and get them out. Now, most sheriffs I see act in about 4 days to 30 days. That's the range they typically act. I've never seen any shorter than 4 days. I have seen some longer than 30 days. But once again, this is also pre-COVID. So I can't guarantee what those timelines would be now, just because the courts are so behind on everything that it's going to take a while for them to get up and going again. So once again, this even gives you more time to get that property refinanced or sold. But I think it's still safe to act with the shorter timelines, because then this way you just put things on a short timeline to get things done rather than allowing the client to delay taking care of everything. Now, once the sheriff has taken possession of the property, once again, title's not being transferred. They're just taking possession because they want to sell it. The property is then going to be listed with a realtor. Now, in this instance, most power of sales, most lenders list properties with a realtor at 6% commission. So for my realtor partners here, you guys want to try and get in close with some lenders and become the realtor of choice with them. However, with my mortgage brokers, once again, this is just another cost that they're going to encounter. And same with you, my realtors. This is just another cost that they're going to encounter. So you don't want to allow these costs to accumulate, right? It's just going to minimize their ability to refinance, or it's going to take away any equity that they could have on the sale of the property. So on the sale of a property, here's what's get paid out and in what priority. And I'll start off with super priorities. Now, what happens is a lot of times homeowners, what happens is an individual who owns a business, a sole proprietor, or someone who works a director of a corporation, if a business is faulting, business most times falter, and what they start doing is they start eating up their HST money. So rather than paying out HST as they're supposed to, they start using the HST to operate their business. HST is the #1 killer of all businesses. In that instance, HST is a trust fund. So it's not the business owner's money. It's not the business's money. It's a money that the business collects on behalf of the government. So it's a trust money. It's a deemed trust. And if the sole proprietor uses that money, they're using that money and they owe that money back dollar per dollar. If the corporation uses that money, the corporation will owe that money, and then the directors will be responsible under director liability for that money. Okay, so that's one of the concerns about being a director on a corporation, because you are responsible for any HST and tax problems personally, your personal assets too. So in a sale of a property, HST or any other debts that are owing to CRA, super priorities, such as HST and source deductions, those are paid off first. After that, property tax arrears and any condo arrears. After that, any expenses that the lender had to cover in order to sell the property, such as real estate agent fees, legal fees. The next would be the lender has to cover their own principal, interest, late charges, any other fees that they've encountered, interest, per diem interest, discharge fees. Now, what's important to note is the moment that the property is taken possession by the sheriff, the lender at that point has possession of the property. And the lender at most times at that time will hire a property manager to maintain that property, because otherwise the property is sitting there vacant, right? They want to make sure that there's nobody squatting in it, taking over, wrecking it. So a property manager steps in. Now, property managers charge a fee, a daily fee. I have seen fees anywhere from $50 to $150 a day, that they're charging to the lender to maintain that property. So if you imagine, if that property sits there for a month, that's $50 each day, $250 each day on top of the lender's mortgage and all the other fees, okay? After that, any subsequent mortgages. So if there's a second mortgage, a third mortgage gets paid out. Any liens that are after that get paid out, such as construction liens, any claims, or any writs. As long as they're after the mortgage, they all get paid out, provided there's enough money. And then, if there's any money left over, that leftover money goes to the former home owner. So, when selling under power of sale, the lenders take their duty very responsibly, right? Because the lender knows that if they don't take their duty responsibly, they could be charged with what's called an improvident sale, which is where they sold the property under value. So the lenders will take typically 2 appraisals, and they'll get a current market assessment also from their realtor. And what they will typically do is they will try and typically sell the property for the amount higher than the appraised value, the average of the 2 appraisals. Most lenders will also not sell to any related parties or any parties purchasing on behalf of the previous homeowner. In the instance where there is an improvident sale, the former homeowner can bring an action in the courts and claim that the lender sold the property off for undervalue and that they should be owing back money to the homeowner if there was any equity existing, but typically there's not, right? Improvident sale is a very hard one to claim, but what they could do is say, hey, let's say the property is worth $160, they sold it for $60. Well, in that case, they have a claim for $100,000. Now, if they owe money to anybody else, creditors, anything else, that comes out of that $100,000, right? And if there's anything left over, they can claim the rest. The previous homeowner can claim that they should have the rest of that money. But once again, most lenders will not sell for dramatically undervalued because it's just not worth it to them. They want to recoup as much money as possible. But there are instances where, like, let's say a private lender will just want to recoup what's owing to them, and they don't have any concerns about what's after theirs. So if there's a second mortgage, third mortgage, they're not as concerned about that. But then those lenders, second, third, or whatever after, can also claim improvident sale. So once again, it's not really in their worthwhile to sell undervalue. Now, when
Geoff, sorry, another quick question. Is there a reason why they wouldn't sell to a family member?
Typically, it's considered a conflict because typically the idea is because they're selling to a family member, it's because it's really the previous homeowner is coming back in the property and they don't trust that person because they didn't make their payments. So they don't want to sell off to them again because they're afraid they're just going to go through the entire process again.
Oh, that makes sense. Okay, thank you.
No problem. So when buying under power of sale, or even a tax sale, as I talked about previously, here's the most important thing to remember. You are buying the property as is, okay? So most mortgagees will insert a non-negotiable clause in the agreement of purchase and sale and the power of sale documents, which says that you are buying the property as is. This is non-negotiable. You can't claim, like any new purchaser can't claim that, hey, I have these problems, right? No, it just doesn't exist. You're buying the property as is. And here's the type of problems that you're going to typically see. Property description. So I know properties by a description. Lot 3, part on plan 58M1237, subject to WR 15679. So that's a property description, things that I see all the time. I suspect you guys would see it because when you look on Purview, underneath Purview, the picture, the map, there's a property description. So if you ever look there, that's how we see the titles. Now, if there's a problem in that, that's how you got the title. That's your problem. That's the new purchaser's problem, right? Same with any zoning. Let's say if there's a zoning issue, a planning act issue, if it's not structurally sound, if there's any outstanding work order saying the city told them to fix something, if there's any registered or unregistered easements or restrictions, any encroachments, right-of-ways, if there's any Title II or removal of chattels in the APS, and as you see, these are all title problems, right? They're all title problems related. So if there's a title problem, too bad. That's how you're getting it, as is. Okay. The other side talks about post-sale adjustments. So a lot of times on a sale of a property, just any property, there's going to be adjustment. So let's say I'm selling my property and I paid my property taxes for all of 2020. Well, I'm going to get an adjustment for my property taxes to the day of closing, right? So any new purchaser is going to pay back to me the amount that I've overpaid. Well, on a power of sale, there's no adjustments. So if the previous homeowner had overpaid something, the new purchase, there are not going to be any adjustments. But typically, the previous homeowner doesn't overpay. It's truthfully the other way around, where the previous homeowner has underpaid or is behind on things such as taxes, condo fees, utilities, right? Anything such as that, those all would be attached to the property, and they can be paid out from the proceeds. But if there's not enough proceeds, then the new purchaser has to take liability and responsibility for those. And title insurance would sometimes cover some of them, but in this instance, these are pre-existing conditions which title insurance will not cover. As I mentioned, construction liens and condo liens. Most times they'll be paid off from the proceeds of the sale. But in the instance where there's not enough money, then they will still remain on title, and any new purchaser has to deal with these condo liens or construction liens. Now, a condo lien typically gets paid off before the mortgage anyway, so you wouldn't have to worry about a condo lien. But as the construction lien is the one that's concerning, because that can continue on. Okay. So let's talk about this. Under the Mortgages Act, a mortgagor, which would be the previous homeowner, has the ability to redeem that mortgage at any time prior to the sale of the property. So if you think about it, let's say the closing date is July 1st. You there as a mortgage broker, even though they've lost possession of the property, you could keep working on a mortgage for them and close before July 1st on the property, and your client would get the property back, even though they've been out of possession. So my invitation to you as my mortgage brokers, keep working. If they've lost possession, as long as the numbers still work, as long as it still comes together, keep working because you can get that property back, okay? The courts have said, though, however, that a sale means effectively when an agreement of purchase and sale, the conditions of an agreement of purchase and sale have been waived and the agreement becomes firm. But most lenders include in Schedule B a clause indicating that the new purchaser has to understand that, and it's non-negotiable, that if the equity is redeemed prior to closing, then the deal is done. And then at that point, the previous homeowner gets the property. So from a realtor's perspective, this isn't the most advantageous for you because then you could potentially just lose a commission, right? Because if you're on the buying or selling side, right, of that power sale deal, you're not going to get paid. Okay. So lesson in that one, brokers, keep going. You think it's over, you have until the new day of closing. Keep going. So we've been talking so far about what happens when the property is occupied by the homeowner. But what about tenants? When there are tenants in the property, a power of sale proceeding does not vitiate, does not defeat the lease, does not result in the tenants having to be evicted. No, the tenants stick with the property, and any new purchaser that buys the property buys it as a rental property with the tenants in it. Okay? Unless, here's the thing, if the property, let's say the homeowner is in the property and they're sharing this property with tenants, such as they share a kitchen or they share a bathroom, then in that instance, the property does not, it's not a tenancy under Residential Tenancies Act. And in that case, all people can be kicked out of the property, evicted, and possession taken by the borrower or the lender, okay? And if, let's say that the tenant in the property is on a month-to-month tenancy, when at that point, the lender that's taken possession can bring an application to the landlord and tenant board to end that tenancy and have that tenant evicted. But if it was a yearly tenancy, or if there's a term on the tenancy, a yearly tenancy, and there's a written contract for a year, then you can't get them out prior to that 1 year mark. So under the Residential Tenancies Act, there are grounds used by lenders in order to get tenants out. So the number one ground is if the tenants aren't paying the money to the lender. So now this is the time between occupation and the closing of the new property. During this time, if the tenant's not paying rent, the lender can go to the landlord tenant board and have them removed for failure to pay rent. Also, the lender can go to the landlord and tenant board, have them removed if they're refusing to allow entry to the property to sell the property, right? Those are the two instances where the lender can take action against tenants. Now, if the lender goes to the landlord and tenant board and takes an action, and the landlord and tenant board says, yes, these tenants are to be evicted, they're not evicted the next day. The landlord and tenant board will typically give them 60 days in order to get out. So where a lender has sold the property is being sold with the tenants. So any new purchasers have the ability to get the tenants out, provided the new purchasers are going to live in the property, a family member is going to live in the property, a child or parent is going to live in the property, or a spouse is going to live in the property, or a person who provides care to one of these individuals is going to live in the property. Let's talk about commercial tenancies, because these are completely different. So in the instance where a commercial tenancy exists, if a tenant enters into an agreement with with a landlord after a mortgage has been taken out. So let's say the mortgage is registered July 1st. And let's say a new tenant comes in July 2nd, right? It's after this July 1st mortgage. Well, if the mortgage goes power of sale, the lender who steps in here can kick out this tenant because the tenant was after the mortgage. They can kick them out the very next day. That's how commercial tenancies exist. However, if the tenant came in first and the mortgage was after, well, provided this lease was registered on title as a leasehold interest, and provided there's 3 years or less remaining on the remaining term, then this tenant gets to stay in the commercial property. However, if this lease was not registered as leasehold interest, the tenant can be kicked out right away. Or if it was registered, but there's more than 3 years existing, they can only stay a maximum of 3 years, okay? Now, during the period of taking possession and the power of sale process, or sorry, the sale, the conveyance of the property, the closing date, any rent can be a torrent to the lender. So the lenders can go and say, hey, you owe me this rent, right? Once again, if rent's not paid, they can have them removed. So let's talk about numbers. Now, what I want you to see is this is Ontario mortgages in arrears. Now, this is a graph from 1990 to 2017. I apologize, I couldn't find anything newer, but I think this does a good job of helping me project where I think we're going to go. If you look in 1990, you'll see that 0.7, that's not even, 0.7%, so that's less than 1% of mortgages were in arrears. And at that time, the unemployment rate was 11.4, right? Remember those numbers, 11.4. The current unemployment rate is 13.7. So what we see is that there's about 2 million mortgages in Canada, in Ontario, each year. And of that, we see there's about 2,000 in arrears, which is 0.1. So it's 1/10 of 1%. But we saw previously 0.7 for 11%. So the projections are we're going to see actually a whole percent, 1.00%. If you imagine, which will result in a factor of 10. So I expect to see at least 20,000 mortgages in arrears. Normally it's 2,000. We're going to see 20,000. So if you think about it this way, if you think about 1% of your clients will have mortgages in arrears. So my invitation to you is take this opportunity, be forward looking, and plan ahead. Look at your numbers, look at your previous clients, and look at them and see who amongst them would be the ones that are going to be in arrears. Who amongst them are non-essential services? Who amongst them have their TDS ratios so tight that if anything were to happen to them, they would be in default? My invitation is to reach out to them, have a conversation with them. As I mentioned before, this is your opportunity. Help save them, save their mortgage. And for my realtors, one of the hardest decisions and one of the biggest arguments I also hear is, I don't want to sell my house. I don't want to sell my home, right? They always say, I don't want to sell my home. But if in the event they can't, and like, let's say they can't get a mortgage, it's better off for them to sell their house and find a new home, start over. At least they will have something. They'll have the equity remaining in their property that they can purchase a new property. They'll still have a good beacon score. They'll have equity, they'll have money. Don't let it get to the point where the court has to make a decision on their behalf, because then at that point, there's going to be nothing left. Real estate commissions, 6%. Property management fees, $50 to $150 a day. That will eat up their equity. Lawyer fees, obviously, we're pretty expensive. We're going to eat up the equity, right? There's nothing stopping any of these people from jacking up their fees, right? If they think that there's a lot of equity there, they could increase their fees. Who's going to challenge them on it, right? Don't let it get to this point. Be proactive, okay, guys? So, we're Rabideau Law. We offer a custom closing virtual signing service. We are fixed fee pricing. We charge $15.99 for a purchase, $9.99 for a sale. And if you do a purchase and sale together, a client brings both to us, they get $100 off each. That's why we provide $23.99. We do refinances for $9.99. We require 7 business days to close. We do remote signings evenings and weekends. And as per our Google reviews, which I was trying to point out earlier, we provide amazing service, and I invite you guys to check us out. Does anybody have any questions?
Some great stuff, guys. Thanks for all that info.
No problem.
Just out of curiosity, the remote signing has been a huge thing. I know for a lot of my clients who just didn't want to go into an office or were restricted. Some of them were stuck out of the country. Is that something that you would see as kind of being a long-term solution because of COVID, or is that just something that will be around?
So we've actually, so good question. We've actually been doing remote signings for 4 years now.
Yeah.
So we actually pioneered the remote signing process.
Okay.
It's just because of COVID, everybody's trying to catch up to us now. So I don't see this changing. It's been a process that we've been doing for 4 years, and we're going to keep doing. And so I don't see it going away.
I would say about 2/3 of our business, Hugo, is done that way now outside the office.
I mean, it makes sense, right? I mean, as long as you can meet whatever compliance requirements. I mean, I would prefer to not have to go physically meet someone if I don't need to, and I can see them on a video call if I have to.
That's okay. We don't want to meet you either.
I don't have to put on pants for it.
Yeah, no. So yeah, it's not going to go away. Now, the requirements of lenders might change. So prior to COVID, we did what called was remote signing. Now it's virtual signing. And so the difference is remote signing was I would send out a commissioner with an iPad or a tablet to the client's home. The clients would meet with my commissioner in person. We would take their ID, we'd scan it, and we'd have them sign on that hardware. Now, we're not sending out the hardware. We're not sending out the commissioner. So we're doing it virtually via video conferencing software. So I have a feeling that the lenders are accepting virtual signings now, but I think they're going to go back to requiring in-person signings, and that's where the remote signing process, what we pioneered, will still be around.
Geoff, Mike Kazarian here. Can you hear me?
Yes, I do, Mike.
So thank you for the presentation. It was great. I do have a question regarding non-residents and remote signings. Obviously, lenders require clients to be here in Canada to sign, but if they're signing remotely, like how would the lender know? Do they have to sign an affidavit or something saying that they're in Canada?
So hypothetically speaking, good question. So the lender typically won't know that they're not in the country. There's really,
Right.
From a virtual signing process, there's really nothing that indicates they're here in the country. We don't sign a statutory declaration confirming that. So there's from a lender side, there's really nothing to prove it.
Okay.
Yeah.
Thank you.
No problem. But prior to COVID, we were doing a lot of remote signings with clients overseas. And what we would do is we would just be sending over the documents to a notary or a lawyer in that country. The client would meet with them there, sign those documents, send them back to us, and then we would complete that purchase, closing, or refinance with the lender.
All right. Thanks.
And sorry, Mike, while I have your question about reverse mortgages.
Yeah, just I guess in terms of foreclosures, I think that might be a good option for clients that can't get traditional financing, because obviously if they're in a foreclosure, they probably have some credit issues. So I just thought that if they had enough equity in the property, that a reverse mortgage might be an option to keep them in the home.
I appreciate it. Thank you. Great suggestion. I'm going to add to. I'm going to steal your idea.
Perfect.
Anybody else? So my invitation is, if you guys want to learn something else, like I do a lot of presentations. I present all the time at SIMBA, and I'm presenting all the time at MPC. I do a lot of these Zoom meetings now, but if there's anything else you want to know about, reach out to Bill, please. I will gladly, I'll gladly present to you or your team. I'll gladly put a seminar on, or maybe I'll reach out to my contacts at MPC and SIMBA and see about presenting to them. But I'm open to suggestion, guys, okay?
That's bcook@rabideaulaw.ca if you want to reach out anytime.